let's pivot now to the New York Court of Appeals decision issued this year. I believe it's pronounced, you'll know better than I, Ferreira? Is that the correct?
I say Ferrara, but
Ferrara, I'm
I'm
sorry.
from the Bronx, so you could pardon my accent. Okay.
And this is a case, because I copied you on the email, that as soon as I read it, I sent it to probably half our faculty, the torts professors, the civil procedure professors, the criminal law and criminal procedure professors, because this case cuts across a number of different areas of the law. It's a civil suit involving a claim by someone who was injured during the execution of a no-knock warrant. And why don't we start there? What is a no-knock warrant?
So let's talk about this case, but just let me give a brief.
Sure.
I lecture all around the state to all these judicial associations, so I'm constantly looking for the next great case. If you ask me, this civil case, Ferrara versus the city of Binghamton, is the most important criminal case to come along in the last 5 years. And why is that? Because it impacts something of great public moment, and that is no-knock search warrants. So to begin, a no-knock search warrant is a search warrant that permits the police to forcibly enter a premises without prior notifications. Ordinary search warrants require the police to, quote, knock and announce first before they execute the warrant. For a no-knock search warrant, it's basically break the door down and barge in. It's a very dramatic and dynamic situation. Surprise is the point. It all stems, of course, from the Constitution, the Fourth Amendment, the right of the people to be free in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched or the persons or things to be seized. The Fourth Amendment does not mention no-knock search warrants. Keep in mind, a search warrant is a court order. Generally speaking, a knock and announce warrant is the default warrant, meaning you have to knock, announce, and the cases say you have to wait a reasonable period of time between 15 and 20 seconds. We are not going to count it out tonight, but that's an eternity for people on both sides of the door, for the police waiting literally with battering rams, and for the persons on the other side of the door. And in the end, the Supreme Court has said a state statute that stated the police are never required to knock and announce, that's unconstitutional. And knock and announce versus no knock is paired with also the notion of any time of the day or night warrants. That's a departure from ordinary default search warrants, meaning under the federal rules of criminal procedure, warrants have to be executed during the day unless there is an exceptional reason why it has to be executed at the nighttime. We have the same rules of law here in our state. And in plain words, what is the showing for the police to obtain a no-knock search warrant? The truth is, and there's a case, it's called Richards versus Wisconsin from 1997, quote, the showing is not high. The police should be required to make it whenever a no-knock entry is challenged. In plain words, it is when there is an articulable danger to the police or anybody else, or there is destruction of evidence as a potential. Now, what's really interesting is if you look at the statistics before we get to Ferrara, what kinds of cases are no-knock warrants used in? Lord knows, Cohen signed hundreds of them, hundreds. mostly narcotics, some weapons, but the statistics nationally are really interesting. 72.2% narcotics, weapons only 3.9%, sexual assault 2%, fraud 7.6%, which is really an unusual number, seems high, and then extortion or racketeering 3.7%. There is about 19% of other. But the bottom line is mostly narcotics, mostly weapons. And so in the end, there has been obviously huge problems. It's not only recently, actually. We've had catastrophic incidents involving no-knock search warrants in which people have been killed for many, many, many years. I have a file that I use when I teach this in class. And in the end, no-knock warrants obviously have figured in today's concern in terms of Breonna Taylor and Amir Locke, but it's been a problem for many, many years. So much of a problem that they are now being restricted by various jurisdictions. Louisiana, Maine, Maryland, Nevada, New Jersey, and cities like Birmingham, Louisville, Pittsburgh, Buffalo, and St. Louis. They seem to be, according to my research, outright banned now in Florida, Oregon, and Virginia. And there was a moratorium announced earlier this year in Minneapolis. And you may remember when President Biden gave his State of the Union address in early March of this year, he actually mentioned the new Department of Justice guidelines, which have restricted no-knock warrants. And it's not merely what I suggested, a potential danger to the police and or destruction of evidence, but it would be permissible to apply for a federal agent working with the Department of Justice when the agent has reasonable grounds to believe that knocking and announcing the agent's presence would create an imminent threat of physical violence to the agent and another person. Imminent threat of criminal violence, a high standard than the very low standard required by the Supreme Court in Richards. So to get to your point, I actually delivered a talk to the Student Bar Association. I prepared all of this about no-knock warrants, and then literally a week before the presentation, Ferrara is decided. And Ferrara answers the question, what happens when there is an injury or damage, if you will, during the execution of a no-knock search warrant? Does a municipality and or the government, if it's federal, have a duty to protect innocent bystanders? Is it a general duty or is it a special duty? Yours truly is not a municipal law expert, but what we have been taught now in Ferrara or Ferrara is critical. Like you say, in Ferrara, it was the execution of what they called a dynamic entry nighttime. It's the combination nighttime no-knock search warrant by City of Binghamton Police. It was an armed SWAT team in 2011. They barge into the house dramatically. The plaintiff was sleeping on a couch and he was shot in the stomach and seriously injured. He happened to have been unarmed. The police later claimed that he had an Xbox controller in his hand that was mistaken for a weapon. Ferrara filed a civil rights action, and you can vindicate constitutional claims, Fourth Amendment, Fifth Amendment, Sixth Amendment, but it's basically Fourth, in civil rights, civil litigation. And he claimed that the police owed him a special duty. He was a special kind of person, and we're going to talk about that in a minute, that they owed him this duty. It goes to trial. Ultimately, the jury awards $3 million. and the city of Binghamton is apportioned at 90% responsible. There's several appeals, and it gets all the way to the circuit court. And the circuit court, remember, is the intermediate appellate court in the federal system. And for our students, well, of course, all circuit court judges are lawyers. And in the Second Circuit here, we only have 3 states, Connecticut and Vermont being the other 2. So the greatest probability is most of the judges in the Circuit Court of Appeals for the Second Circuit, they're going to be New York lawyers, admitted to the bar here in our state. But they needed to know what is the exact rule of tort law in our state. What is the law requiring responsibility, if any, on the part of a municipality? Does a municipality owe a person in the zone of danger some duty? Is it a general duty or is it a special duty? I'll give you the result because it's dramatic, and I'm going to explain why it's dramatic. Not for me, because I'm a criminal guy. For me, it's dramatic because of the impact it will have on the problem of overuse of no-knock search warrants, especially overuse of no-knock nighttime search warrants, which are scary. The Court of Appeals said, and it was Judge Singas. Everybody remember who she was? She was the Nassau DA for at least a dozen years. They ruled 5-2 that yes, there is liability on the part of a municipality, but that liability is predicated on the plaintiff demonstrating a special duty. And I'm going to explain that in a minute. And the court said it can be established in cases involving injury from no-knock search warrant execution. The majority, they say there are basic rules. It's a complex area of the law involving liability for the negligent acts of municipal agents. But a municipality may be liable for agents performing a proprietary function, fire services, garbage collection, frontline emergency services. That's examples given. And they say, following up, there's no question that the execution of a no-knock search warrant is a governmental function. Municipalities further owe a general duty to the public, but this is critical for our students to understand. They owe no duty of care to any one individual unless there is a special duty. What's a special duty? There can be a special duty in one of 3 areas, says the majority. If the plaintiff is in a protected class under a statute, not here. 2, the government voluntarily assumed the duty to an individual plaintiff to create a special relationship. I'll give you an example. A cooperating witness. The government says, we'll protect you. We'll put you in the witness protection program, and they don't. They don't, and I shouldn't say they don't act reasonably. And last, and this is the area that we'll focus on, the municipality took control of a known or dangerous safety situation. The plaintiff has the burden of establishing a special duty like this. And here the plaintiff was a third party in the zone of danger during the execution of that search warrant. And the majority holds. In a no-knock search warrant situation, the police exercise extraordinary government power to intrude upon, well, think about it, the sanctity of the house and take temporary control of the premises and its occupants. I'll share with you, my students know this. I have a doormat in my porch. The doormat says, come back with a warrant, because it's a serious thing when you breach that door, much less in a dynamic way. But for a no-knock warrant in such circumstances, the police direct and control a known and dangerous situation. As a result, the municipality's duty to the individuals in the targeted premises, a limited class of potential plaintiffs, exceeds the duty the municipality owes to the general public. And so The execution of a no-knock warrant is a charged and volatile situation, and it is a requirement that the municipality take the steps to reasonably foresee and avoid many of the risks occasioned by the uncertain reactions to chaotic events when the police forcibly cross the threshold. I think we lawyers speak that way, and certainly we judges do. They're breaking the door down with a battering ram. It's literally a terrorizing situation. And so, holding a special duty arises when the police plan and execute a no-knock search warrant, and it runs to the individuals within the targeted premises. And in those circumstances, the police take positive control of a known and dangerous situation. The dissent is fabulous. Judge Wilson is one of the great writers on the court today. He and Judge Rivera would have held there was a general duty. Several times in the opinion, he stresses maybe it's a question of semantics, but there's a duty of reasonable care. And I'm not from Brooklyn, but as they used to say in Brooklyn, irregardless. It's not a word, it does not exist. But what he says is it includes a general duty to protect bystanders, third parties, during that scene. Why is this an important case? Lord knows, I know nothing about municipal liability except this. I am a police chief or a commissioner of police or a supervising police officer. I have a police officer come to me and say, we want to do a no-knock nighttime search warrant. I now have been told by my corporation counsel, by my Department of Justice civil lawyer, by my county attorney, that there could be municipal liability for failure to plan and take appropriate steps to minimize the risk. Example, what was Ferrara doing on that couch? He was an innocent person. Did the police know he was in the house? I don't know the answer to that question. But for our students, I believe this case, more than any one criminal case, will have the most salutary effect on applications for no-knock search warrants. In the end, it will precipitate at least a clear path for liability, because the Court of Appeals answered the Circuit Court of Appeals question. This is New York law. I don't know how they're going to rule, because they will have to decide, did the plaintiff in Ferrara demonstrate sufficient facts to make out special duty? The dissent, and that's again Wilson, Judge Wilson says the majority, he uses a word that's really interesting, littered the decision with all this stuff about special duty. They needn't have gone there, because maybe it's the same thing, but police owe a duty to people in the zone of danger. What does this mean too? Instead of being routinely used in certain cases, that is narcotics and certainly weapons cases, it will be something that police will be wise to think about, more loath to execute as a matter of routine. Also, remember the notion of qualified immunity. The police have qualified immunity if they act reasonably according to settled federal law, clearly defined law. There can be municipal liability under Monell for failure to train and supervise. In the end, police who don't act properly and can be proven to have not acted properly, such that there's serious physical injury or death, there could be liability. I understand qualified immunity means compensatory damages are reimbursed. What about prosecutors? Can prosecutors be liable? You know, there's a case from 1997, Kalina versus Fletcher. If you want to look it up, it's 118 Supreme Court 502. A prosecutor who acts outside, it's a her prosecutorial function, but as an investigator, in that case, preparing affidavits for a search warrant, can be liable and only be given, not prosecutors get absolute or prosecutorial immunity like judges do. They would only get qualified immunity because they'd be acting in an investigative capacity. If I am a prosecutor, I would be very frank to say, since most large metro offices have lawyers drafting search warrants, I would be awful careful now in drafting and applying for a no-knock, certainly any time of the day or night, search warrant. And I think, again, this is the power of the law. In other words, there have been all sorts of efforts, as we explained, in the no-knock area to limit it, abolish it, etc. And in the end, this decision will, by its own nature, constrict the application process, I think. I hope that was not too long-winded, but it gives students an understanding how the law really can meet the challenges of the day.
Yeah, there's, you said a lot, and you hit on a number of interesting points. And the one thing I want to make sure that, anyone who's listening appreciates is, about 3/4 of what you said, was a very helpful walkthrough of the Court of Appeals decision. And then there's this last piece, which I want to make sure isn't obscured, because this idea that, because it's sort of, I think it's reflexive to think prosecutor, absolute immunity. And you're flagging something that says, not so fast. It isn't that simple. Because in this context, just to say back what what you said, it's that you're acting as an investigator. And that means that in that context, you are not entitled to absolute immunity, because I think that's qualified immunity is a shield, but it's not absolute.
And it's true. And I must tell you, as a prosecutor, I was aware of the differences between investigative and prosecutorial roles. And so when I would prepare a search warrant, I would know I would be doing it very consciously. I'm stepping outside here. I am not like standing in a courtroom. Anything a prosecutor does in a courtroom, even outlandish, he or she is going to be protected as against civil actions by absolute immunity. It's like a judge. But here, if the prosecutor is part of drafting, one could argue that the prosecutor has no role in the strategy formulation or tactics of the execution of a search warrant. It may or may not be the case. I've been involved in cases as a prosecutor. It involved a massive search warrant effort, maybe a dozen or so at the same time, involving more than 100 executing detectives. You had to have many in many different places. And so, quote, I was involved in that. And so I was involved in the tactics and the strategy at the time. These were not no-knocks that I can remember. But in the end, a prosecutor who is concerned about his or her civil liability will be well advised to think about, do I really need a no-knock warrant? Because in the end, a no-knock warrant, when a judge gets one of these, the judge oftentimes is looking over a table at the detective. And the judge makes a decision. Is there, it's a low threshold, a sufficient basis to grant the no-knock warrant? Or is he going to send this detective into a scene in which he could be shot and killed? It's a really, really dangerous situation on both sides. And so a judge, if he or she is going to err, is going to be persuaded to grant it if there is a sufficient indicia. And again, it doesn't take much to grant one. This case, though, may prove the point. They may not be wanting to ask for them because you bring on this liability and responsibility that you wouldn't otherwise have.
This has been really, really interesting. And it's always so interesting to talk about the law with someone who actually practiced it. Here's the last question, which I think really might sort of take us back or loop us back to, the first part of the podcast, which, you now teach at Toro. You've taught there for decades, as we said at the beginning. So in your criminal procedure class, where would you teach this case? When would you present it to the students?
I actually have started using civil liability cases. And it's an interesting thing. I didn't used to do this. I mentioned this case. I didn't make the students read it, but I mentioned it when we learned about search warrants and what's no-knock, what's knock and announce, and any time of the day or night. I think it's important that the students understand this dramatic change. And I think a case like this, to be frank, I have actually used it in speaking to criminal groups, meaning criminal groups of lawyers. And I think judges need to know about it, lawyers need to know about it, and most important, law students need to know about it because they're the ones that are going to make this actually real. They're going to get a case, and they're going to get a case to say, wait a second, I got to establish at least a special duty. I think owing to Judge Wilson's notion, maybe it's a question of semantics, that's the holding and the answer to the question back to the Circuit Court of Appeals. But in the end, that duty can be established. And because that duty can be established, it will restrict and circumscribe the number of cases that I think are applied for in the future.
Yes, yes. Well, thank you.
Thank you. It's been a pleasure.
I think we're gonna wrap it there. But it really has been a pleasure. And of course, I look forward to seeing you soon, maybe even in person.
Yes, yes.
So
thank you again for the opportunity. It's been a real pleasure. And I thank the Law Review as well. Thank you.